Hello everyone, this is Lerone Kuntz. I'm here in Fulton County, Georgia, and I'm here to give an update on the Fani Willis case. As you know, Fani Willis is the district attorney here in Fulton County, Georgia, and she has a RICO case against President Trump and 18 others, saying that they tried to steal the election in 2020. And so this investigation about her relationship with the special prosecutor, Nathan Wade, keeps evolving. And now we have cell phone data that was submitted by Trump's team saying that she and Wade lied when they came in front of the court and testified about a week and a half ago and said that their personal romantic relationship started in February of 2022.
If I understand your testimony, there was no romantic relationship with Mr. Wade until early in 2022, whether it be January or February or March, early in 2022, correct?
I would say sometime between February and April. Yes, sir.
All right.
Let's be clear. 2022 was the start of any intimate sexual relationship with the district attorney.
They're saying this cell phone data shows that their relationship, their personal relationship, started before that. And they have a period that they're focusing on in this document. And that period is January 2021 to November 2021. And they're saying within that period of time, there's been over 2,000 telephone calls between Fani Willis and Nathan Wade, and there's been 12,000 text messages exchanged between Fani Willis and Nathan Wade. And they're saying that that is not indicative of a business relationship. That is indicative of a personal romantic relationship. They're also highlighting in this report that they have 35 instances where they can show that Fani Willis and Nathan Wade were together at her house for extended periods of time. Now, this flies as a conflict of Fani Willis's testimony when they asked her about Wade coming to her house.
Yes.
Okay, could you give us an approximation of how many times Mr. Wade visited you at the condo between the time you moved in and prior to November 1 of 2020?
I don't think often, but I don't want to speculate.
Can we say more than 5, more than 10?
I'm going to tell you the problem I'm having here. Let's say more than 10, but I'm not sure that that's even accurate. He certainly has come and picked me up, gone to grab some food to eat. I don't remember him being in that condo a lot.
They're also in this document, they have highlighted two instances. One September 11th, 2021, and one November 29th, 2021. On September 11th, 2021, they're saying that they have cell phone data that proves that Wade left his house in East Cobb and traveled to Fani Willis's condo, which is in Hapeville, not Hateville, but Hape, H-A-P-E-ville, and arrived there at 10:45. He left at 10:15 p.m. He arrived at her house at 10:45 p.m. and he stayed at her house until 3:28 a.m. Left there and got home at 4:05 a.m. and at 4:20 a.m. he called her back, I guess to say, hey, I made it home. And they're saying that that is indicative of a romantic relationship. And it's interesting to me because I'm familiar with East Cobb, where they're saying that Wade lives, and I'm familiar with Hateville. And I know when I GPS those areas, they're 30 minutes apart. And the times that they're saying that it took for him to get to and from her house were about 30 minutes. They say he left his house at 10:15 p.m. and arrived at her house at 10:45 p.m. That's exactly 30 minutes, right? And then they're highlighting November 29th as well, and they're saying that she called him around 11:32 p.m. and he arrived and while he was on the phone, he started driving, and he arrived at her house at 12:43 and stayed there till 4:55 a.m. So he got the phone call at 11:32, and while he's in the car, he drives to her house, and he arrives there at 12:43 a.m. and stays there until 4:55 a.m. So they're saying that they were together on these 2 nights, and that is not indicative of a professional or business relationship. That is indicative of a romantic relationship. And so it's going to the heart of their testimony, and if it can be proven that they lied under oath, that's very serious. That is serious business. And so this whole investigation is taking on a whole new look. Now, and as a result of that document that was filed by the Trump team, of course, Fani Willis files a document saying that the court should not accept this data. And her angle or her motion relies heavily on the standing case management order that was distributed to both sides at the beginning of the case. The judge here in August gave them rules that he put forth as it relates to how you're supposed to introduce evidence, how you're supposed to introduce evidence from an expert witness testimony and things like that. And they're saying that the Trump team have violated all those rules. They were supposed to give them advance notice as to, who they were going to call and what they were going to discuss or introduce. They were supposed to let the court know. They were supposed to let them know, and they didn't do that. And they outlined the things that the court said when they first started the trial. And they have a passage here that says, experts, any part seeking to rely on expert testimony at trial or any evidentiary hearing must provide written notice to the opposite party, must include a meaningful summary of the expert's testimony, as well as his or her qualifications to serve as an expert witness. This notice must be provided at least 14 days before the final plea trial calendar call and 7 days before any evidentiary hearing requiring expert testimony. And they're saying that Trump team didn't do any of those 4 things, so the court should not accept this data, okay? And they're saying that they are not sure that this data is even legal, that, a warrant may have had to be issued, and they don't know anything about any warrant being issued, so they're questioning whether or not this is information that was gotten legally, right? And then, like I said, it relies heavily on the judge's order. They keep mentioning, you said, Judge, this is the orders that you put forth. It's sort of like saying to the judge, you made the rules, and you can't change the rules in the middle of the game. You got to be consistent. And after they make that case very clear, they say, but Judge, even if you find some reason that you want to accept this data, it's not good. This data is faulty. It doesn't prove anything. It doesn't prove that we were together. It didn't prove where we were, the scope of the transmissions and the cell phone tower thing. It's the area is so large that it can't be pinpointed like this. And she goes even further, and she says that, and on some of the occasions, I was working. And she has said, see Exhibit C. So I'm looking at the motion. I'm saying, wow, if she can prove that she was working during the time they're saying that she and Wade were together, then that should be the end of this. And so I go to Exhibit C, and I see a lot of emails that have been redacted. I don't have a problem with them being redacted because the information may not be suitable for, public consumption. I get that. The thing she's focusing on that's not redacted are the dates of these emails. And she's saying that she sent these emails from her office. But the dates do not coincide with these 2 days that are highlighted in this report. Now, I think that the Trump team submitted a lot of data from November for 11 months worth of data. So there's a lot of stuff there that they didn't highlight. They only highlighted these 2 days where they're saying that they spent the night together. So I'm thinking that Ms. Willis must be referring to other data when she's showing these emails, because these emails are from April 2021, May 2021, October 2021. They're not from the dates that the Trump people are saying they were together. So I figure that she is trying to say that the other information is not right, so this information about us being together is wrong too. But like I said, none of the dates of her documentation are for the dates that are highlighted in the Trump report, okay? And that seems like the dates that should be the ones that she focused on, but maybe she doesn't think that. Okay, as a response to her motion, the Trump team comes back with their motion. They're saying that the information that they are submitting is not expert testimony. The person who prepared the report, Charles Millerstadt, is not an expert. He is just someone, an investigator, who has the training and to understand the cell phone data, and he put it in a report to give to the court, as opposed to just giving, I guess, cell phone data in a report that the judge may not be able to interpret. They had somebody to explain it. They're saying he's not an expert. He's not giving an opinion. He's just saying pretty much this cell phone connected to that tower and this particular time. And so it's not expert. He's not an expert witness, and it's not expert testimony that it should be accepted. And they have, they're making the case using case law. And let me just tell you, each side is using a lot of case law in their motions. So this side is saying, Trump side is saying that there's a lot of case law where people have come to court and have introduced this same exact type of evidence into, this information into evidence, and they weren't experts, and the courts have held that that's okay. So they have plenty of instances where courts have accepted this information. And then they're going to the next point, and they're saying that this information was acquired legally. They said they just submitted a subpoena to AT&T. They said they also submitted one to Delta. They didn't get the stuff back from Delta, but they got the stuff back from AT&T. And when they got the stuff back, they analyzed it, put it in a report, and sent it to the court. That it was nothing illegal done. It's a normal subpoena that lawyers submit to the court. To the cell phone companies, and they get the information. Everybody does this. It's no big deal. They didn't need a warrant to get this information. So that's what they're saying about that. And so they go on to say that the information is reliable, that they're using the same type of software that is used all over the United States to decipher this data, and they say that Georgia also uses the same sort of software, the same exact type of software that they use to analyze the data. And so they are going past that point, and then they're saying that the data is good, and they're highlighting the fact that Ms. Willis's office, they gave you documents, Judge, talking about dates that she was in her office and that she was doing other things, but she didn't talk about the dates that we're highlighting in our report. You know, isn't that suspicious that she's not talking about the dates that we're saying that they were together? And that is the information that they want to get in because it contradicts their sworn testimony. And they're also saying to the court that courts have accepted information that contradicts someone's testimony. You know, whether it's someone coming in and saying, hey, that person is not telling the truth, or whether it's somebody who has a picture of somebody that says, hey, you know, he says he wasn't in this area and I have a picture saying he was, you know. So they're saying this type of evidence is like that. And they say courts traditionally want to hear this type of evidence that contradicts someone's testimony. And, you know, if you're trying to get at the truth, then you should accept the information. And they're saying that we're not claiming that we know what they were doing together. Only Wade and Willis can tell us what they were doing together. And, you know, we should have them testify because at this point, it sounds like they weren't telling the truth because they both testified that their romantic relationship didn't start until February of 2022. And they were together spending the night in 2021. Also, Fani said that, you know, no one stayed at her house during 2021. You know, she was hard pressed to remember that her own daughter had stayed at the house. So this all flies in the face of what the sworn testimony was of Wade and Fani Willis. And so at the end of their motion, they say, they wrap it up like this. They say the cell phone records that show that they were talking on the phone and then ended up at a location near or at her condominium for 5 hours makes more than just one fact more likely than not. That one, they spent the night together on those 2 occasions, and 2, their romantic relationship or their romance began before Wade was hired. One more fact is also more likely true than not. 3, neither of them testified truthfully at the hearing on February 15th. That's what they're trying to prove. And this is serious, okay? This is serious because people go to jail for lying under oath. And there's a lot of examples of that happening. I mean, these 2 people are lawyers here, right? And lawyers lose their law license or have their license suspended when they get caught up in stuff like that. And, you know, it doesn't matter whether you're the DA or a special prosecutor because they have suspended President Clinton's law license because he lied during the investigation of his relationship with Monica Lewinsky. And I have it right here from Arkansas. The Arkansas Supreme Court suspending President Clinton's license for 5 years in 2001. And it says, the agreed upon discipline filed of record with the Pulaski County Circuit Court reflects that Mr. Clinton admitted to giving knowingly evasive and misleading discovery responses concerning his relationship with Monica Lewinsky. So they can take a president's license and suspend it. Then they can actually take Willis's and Wade's license as well. So this is important. This is serious. And there's also another case that I want to talk about briefly that's very serious. It's the case of Scooter Libby. Scooter Libby was the chief of staff for Vice President Dick Cheney. And he was convicted of obstructing justice and lying under oath. And he was sentenced to 30 months in jail and a $250,000 fine. His sentence was commuted by President Bush, but he still remained a convicted felon because he lied under oath. So this is serious business. So what I think is going to happen in the long run, how this thing is going to be resolved, is by those 12,000 text messages. Now, that's a lot of text messages. When I think about that, I'm like, wow, within 11 months, they generated between them 12,000 text messages. You know, I don't even know whether I have those many text messages at all. You know, that's a lot of text messages. And it appears to me that Fani Willis is the type of person that likes to talk. You know, she didn't really have to take the stand. Her lawyer was negotiating or making the case for her that there was no need for her to take the stand at this hearing. And she just came in during this debate with the judge and the defense attorney, and she just said, hey, I want to talk. I want to sit down. I want to tell my story. She seems like the person who's very vocal and wants to be heard. And probably in these texts are a lot of information about their relationship. Or you could probably read into the text what type of relationship they had. So I think eventually the court is going to have to get those 12,000 emails. And that's either going to exonerate Wade and Fani Willis, or it's going to bury them. Okay, because if there's stuff in there like, honey, can you come over right now? And we had a good time last night, I love you, and all this other stuff, it's going to really look bad. So I think inevitably it's going to get to that in this case where they may have to go into those emails. But if there's nothing there, if there's just a professional friendship, business friendship going on, it'll be in those texts too. So it'll exonerate them and this thing will be put to rest. So I would like to see what's in those text messages. I'm sure the world would like to see what's in those text messages. So that may be the next thing that's going to happen. The one elephant that's still in the room about this case is the speech. The speech she gave on Martin Luther King Day, because that was one of the things that the Trump team brought in to initiate this hearing. And the judge looked at the 4 points that they brought in, and he said, yes, we need to have a hearing on this. So I don't think that this whole thing is going to be shut down until they actually talk about that speech that she gave on Martin Luther King Day. And she talked about race as it relates to this case. And the defense is saying that it racialized the case and it made it almost impossible, if not impossible, for them to have an impartial jury selected for this RICO case. So I'm waiting to see that too. So thank you guys for coming in again and checking me out. Thanks for everything. And when we get more information, oh, and I am going to do a video about Terrence Bradley, okay? I'm going to definitely do that. So as always, until next time, peace and stay safe.